Sorry about the slight delay to kicking things off there, but good afternoon and welcome to this afternoon's webinar, which is on employment practice liability claims. My name's Heidi Buckingham and I'm a sales and distribution consultant here at Zurich, and I'm joined today by Rose Sutton and Julia Wallace, who are from our financial lines claims team. And we've also got a special guest this time around. We've got Anjali Sharma, who's joining us from DAC Beechcraft, where she is a legal director. Just a little bit of housekeeping before we get started. So everybody is on listen only mode at the moment, but if you have any questions throughout the course of the webinar, please feel free to pop them in the chat box and we'll answer those at the end. I can also change the settings at the end of the webinar. If you do want to come off mute and ask a question, feel free, or you can just ask things in the chat box. As I mentioned, the webinar is being recorded this afternoon and I will send around a copy of the recording and the slides that we'll go through afterwards. Please feel free to forward these on to any of your colleagues if anyone else would like to watch what we've talked about today. And I will also send around a feedback survey afterwards, which we're always really grateful if you can fill in. It only takes a couple of minutes, especially about future topics that you would like us to talk about in our webinars. But I think that's everything to get going with, so I will hand over to Rose.
Hello everyone, and thank you so much for joining us. The aim of this webinar today is to hopefully give you some information on employment practice liability and the employment tribunal process, as we appreciate that sometimes management liability might not necessarily be your main line of business and you might see these claims less frequently. But hopefully the information we give you today will better equip you to be able to advise your clients when these type of claims do come across your desk. If you wouldn't mind moving to the next slide, Heidi. Oh. Heidi? Can anybody else see the next slide?
Sorry, we're having nightmare technical problems today. Actually. Let me try again. Is that better?
Yeah, perfect. So we're going to go through the employment tribunal process, some common coverage issues, and some examples of claims that we regularly see. This is us. Heidi already has introduced us, but I'm Rose and I'm a senior claims handler in our financial lines team at Zurich. So Julia and Angie, you'd like to quickly introduce yourselves?
Yes, I'm Anjali Sharma. I'm a legal director at DAC Beechcraft. So we're one of Zurich's panel firms and we primarily deal with EPL claims. So you'll have the joy of me talking to you this afternoon just about what an EPL claim is, to bring it to life for you a little bit more so that it's, when it does land on your desk, you do know what it relates to. Julia?
Yep, I'm Julia Wallace. I'm a claims controller and solicitor within the financial lines claims team. I've been in the team 7 years, but dealt with the type of claims we're going to discuss today for about 13. So I think on to the next slide.
Yeah, and we also have Tony Statham on the call. I'm not sure if he's able to speak at the moment, but so if you have any underwriting specific questions for the end, then Tony's here to help with those. So just in case for everyone's information, that employment practice liability insurance provides cover to employees for claims made by employers for claims made by employees for employment related issues. And these are the most common types of claims we see being notified under the Executive Risk Solutions Policy, which is our SME and mid-market product at Zurich. And we only expect this to continue with the current economic crisis and more businesses having to make employees redundant, etc. And the most common types of claims we see are claims for unfair dismissal, constructive unfair dismissal, and discrimination claims. And normally they come as more than one of those in one go. Next slide, please, Heidi. So I've got some statistics here from the Employment Tribunal, and these are from the most latest publication from them. So this is April to June 2022 figures. We have 19,000 there, which is the number of claims filed with the Employment Tribunal just in that period of time. which is a phenomenal number really, especially as if you consider these don't include those which go through the ACAS early conciliation period. These are just ones which go to the Employment Tribunal. And this is actually a 10% decrease from the same period last year. But this is in the context of COVID and there being an increased number of claims during the COVID period, but still a very large number. And then the next stat we have is that 114%, and that is the percentage increase of claims which have been disposed of in that period of time, since the same period of time last year. And that means that they've been resolved or closed. And that signifies, if you like, the employment tribunals catching up from the post-COVID time where the employment tribunals were got so behind with claims not being dealt with for really large periods of time, but they are starting now to catch up with that. That figure there is the largest award made by the Employment Tribunal in April to June 2022, and that was for a disability discrimination claim. So some pretty large amounts of money involved. And the final stat we have is £5,664, which is the average award which was made by the Employment Tribunal in that time. And I think something to consider with that number, although it doesn't seem very high, is that to have got to that number, a significant amount of defence costs will have been spent in resolving that matter. So we'll often see that these claims, we try to settle them before they get to this stage, because you'll be our kind of average estimated defence cost budget for the resolution at the end of an employment tribunal process would be upwards of £15,000. So the actual claim cost is much, much higher than that 5,664, and you could have potentially have settled that matter at a much earlier stage for that amount or even less. So just some statistics there to hopefully set the scene. And now Anjali will bring them to life for us by talking through the employment tribunal process.
Thank you. And as Rose set out, actually, employment tribunal claims, they're not typically what you guys will probably see. They're either a standalone policy from an EPL policy, or they may have been an add-on under your D&O policy, or an extension of another part of your policy. But I think the important thing to really take away from here, from my perspective as a panel lawyer in dealing with these types of claims, is that these can be really, really costly. The £265,719 that we saw on the last slide, it's not an anomaly. I can't say that word very well, but actually what that does take into account is that probably was an unfair dismissal claim and a discrimination claim. Just for your information, we're not going to go into this in too much detail today, because I just want to talk to you guys about the process for an employment tribunal claim. But a discrimination claim has no statutory cap on any award of compensation. So if you have a discrimination claim where the insured is pretty much banged to right, it could be tens of thousands, hundreds of thousands of pounds. You'll see the figures floated around in the press. We had the very legal Daily Mail litmus test, where you'll see 6-7 figures bandied around in terms of discrimination claim. They are the exception. They are not the norm. Just for your information, an average discrimination award is between 10 to 15,000, depending on the severity of the discrimination that the individual has suffered. So we are not always talking about 6-figure settlements in EPL claims, but you have to be aware that these claims can be really, really costly. Also, the one thing I would also say about EPL claims before I go on to the tribunal process is that there is a backlog at the employment tribunal. There is a significant backlog. There was a backlog before COVID even hit, then COVID hit, and then we were essentially shut down for 6 months. Many tribunals, especially the southern tribunals, are listing 3-day hearings plus well into 2023, now into 2024. That has an impact on the life of your claim, because we are seeing, unfortunately, some insureds perhaps not even being around in 12 to 14 months. That then has an impact on how we are able to defend a claim for you guys, especially if we have no insured and no individuals to give witness evidence in respect of those particular claims. So you get a claim. how do we deal with it? How do we identify that it's an employment tribunal matter, or what is it that we need to notice from the outset to consider whether it's a circumstance and notification needs to be required? So we only deal typically with claims in England and Wales. Scotland also has an employment tribunal. We do deal with matters there. Their process is slightly different, but not hugely different from England and Wales. But then you also have the industrial tribunals and the Fair Employment Tribunal in Northern Ireland and the Labour Relations Agency in the Republic of Ireland. The processes are similar, but there are some nuances, which I'm not going to talk about today. I'm just going to focus on what we are looking at in terms of the employment tribunal process in England and Wales. So you have an insured who gets a grievance or gets contacted by ACAS through early conciliation. This is really, really important, especially ACAS early conciliation. Before a claimant, and I'll use that term generally, can bring a claim at the employment tribunal, they have to go through the ACAS early conciliation process. On the ET1, so the ET1 form is essentially their claim form. They have to put the ACAS early conciliation reference number. Now, ACAS early conciliation was introduced about 4 years ago to try and reduce the number of claims which found their way to the employment tribunal. You have to contact ACAS within 3 months of, if let's say you've been dismissed, it's 3 months less a day that you have to contact ACAS to start that process. And it's the same for acts of discrimination. So, like I said, I'm not going to talk about too much about sort of time limits in that regard, but what we have to remember is if we have an insured who's contacted by ACAS early conciliation, and as Rose alluded to, it might well be that all they want is a reference or 500 quid and it will go away. You need to ensure that notification is done at that point. And I know that Julia will be talking about that in a bit more detail on the next slide. But it may not just be ACAS early conciliation that you get. You might actually get an insured who's got a horrible grievance, which basically alludes to the fact that if their grievance cannot be resolved, that they are going to issue a claim. It's at that point you need to determine whether that is enough to amount to notification, and if that's a circumstance that you should be telling Zurich about. If you've got one of those two things, you need to be taking advice in relation to it, speaking to Zurich as to what you should be doing. So let's assume that we've gone through ACAS early conciliation, we've not been able to resolve the matter. What the claimant then has to do is issue their ET1 to the employment tribunal, and that's now all done online. The employment tribunal will no doubt sit on it for 2 to 3 months because they don't have enough staff to process and get through the admin in relation to this. And what we were finding actually when COVID hit as well, because there was nobody in the offices or nobody in work premises, ET1s that were issued by the tribunal would just sit there and they wouldn't get dealt with. The tribunal were a little bit more lenient in COVID days, but now we've kind of moved away from that. We do have to be really aware of the strict time limits in dealing with a defence. So when the ET1 is sent to our insured, what they will get is they will get a notice that a claim has been issued. They'll get an ET2 form, which basically has the date the defence is due, and they'll get a blank copy of their ET3 form. Now, typically, as soon as the ET1 has been issued, worked its way through the employment tribunal process, you have 28 days in which to submit your defence to the claim. That's really, really important. That date is not movable unless you don't receive the ET1 at all, or you know you've got it, but you don't have a complete copy. But fundamentally, even if you get the ET1 the day before the defence is due, that ET2 deadlines, that date on that form is a hard stop date for our insureds. They must ensure that they submit a defence by that time. Otherwise, they will get default judgment against them. Now, it's easy-ish to get a default judgment overturned, dependent on the reasons that we haven't submitted the defence on time. So, for example, during COVID time, if we hadn't got the ET1, then we could explain that we've just got it and we're responding as soon as possible. So, like I said, it's really, really important that if you have an insured who are coming to you and they've already got that ET1, that you know that the deadline is for that defence to be submitted, and that, like I said, that's not a date that's movable. That's a hard stop date. So you have the ET3. you notify Zurich, Zurich notify panel, typically me in these situations, and we draft the defence on behalf of the insured, and then we start to prepare the defence of the claim generally. There are two things that could happen. One is a preliminary hearing. Now, a preliminary hearing in the employment tribunal process, it can be one of two things. It can be an open hearing and it can be a closed hearing. I'll deal with closed hearings because they are typically the ones that we see the most. That's basically a case management discussion where we talk about the legal issues in the claim and we set the claim down for a final hearing. And then you have the final hearing. Now, the final hearing in reality, whilst the tribunal do have statistics and time limits that they have to try and dispose of a claim, the reality is it's going to be 12 to 18 months at the moment before a claim gets to a final hearing. But what we need from our insured during that time, and primarily at the time that we are drafting the defence, is all documents in relation to the claim that's being made. And we're going to talk through about some examples that we have about ET processes and employment tribunal claims, the do's and don'ts, and where it can go horribly wrong a little bit later. But what we would really benefit from ensuring the insureds have is all of those documents collated at an early time so that they can all be sent to us, rather than, you know, Zurich or myself having to go back to insured in piecemeal asking for this information. So that's a really whistle-stop tour of the employment tribunal process. And I know that there are a few questions which have popped up in the chat. I think we'll deal with at the end of the session. But I think the takeaway from my part of this talk today is, if you have an ET1 or you've got ACAS early conciliation or grievance that has been received, that it's notified early, the deadlines are noted. It's not left until the last minute to notify, because some of the claims can be quite convoluted and can be quite lengthy, and we need as much time as possible to be able to put the insured in the best position for the defence, but also to report to Zurich in terms of the merits of the claim. Because like we said, this claim might be worth peanuts, but you're actually spending £10,000 to £15,000 in defence costs to defend something that, one, might be indefensible, or two, commercially is not worth defending. So I know I've talked a little bit about notification. I'm going to pass over to Julie, who's going to talk about it a bit more.
Thanks, Anjali. If we could move on to the next slide, please. Okay, so here we've got a definition of a claims condition in relation to notification. I'm not going to read it out to you, but I'm just going to pick out a few points. So the main thing is, when you get indication that a claim may be made or that you've got an actual claim, that you notify Zurich as soon as possible. And now that's regardless of the insured's view on the merits of the case. For example, they may think they don't need to notify because the claim is exaggerated, or they don't think the person has a strong claim. Or another reason we see that sometimes claims aren't notified is because the insured's notified their legal expenses insurer. Which we would like them to do, but we always want to be notified as well. So it's important when something happens that insured notifies all relevant insurers and not just one, because there could be coverage consequences of falling foul of this notification condition, either by the claim being declined because we weren't involved in the conduct of the claim at all, or we could, for example, limit our liability to some extent to take into account prejudice we may have suffered by the insured not involving us, and allowing us to be involved in the strategy and decisions in relation to the claim. So going back to the condition, there's a difference in here between notification of a circumstance and notification of a claim. So under the condition, insurers have a right to notify a circumstance, but they don't have to. But they do have to notify as soon as practicable a claim as defined by our policy. Now, I'm not going to talk too much about what a claim is because Rose is going to discuss that later, but basically we'd expect a claim to include allegations of wrongdoing, details of who the claimant is, and a demand from the insured. So if that definition has been met, then we should be notified, and we need to be notified to the policy that is in place when the claim is made. Otherwise, this there'll be issues about notification being late and or the claim being declined as a prior claim or circumstance. For a claim, there is also a little bit of an extension in relation to notifying, because we require notification within the policy period, but for when it's a claim, it can be also be no later than 45 days after expiry of the period of insurance. Now, we obviously want to be involved as soon as possible, but that gives a little time if there's any delays in the insured receiving it and things like that, to make sure that it would attach back to the correct policy. So in relation to what the insured needs to provide when notifying us, we need more than just a notification that says, oh, the insured has made some redundancies and expects there may be some claims. That wouldn't be enough to trigger the notification provisions. So it sets out in more detail in the wording what's needed, but what we would need is details of the potential claimant or claimant, details of the anticipated wrongful act or the allegations made, or the reasons for anticipating a claim, and the potential damages, just so we can narrow down and accept as a circumstance or claim under the policy the specific matter in question. Because as I said, a redundancy situation wouldn't necessarily be enough to trigger the policy unless that was accompanied by a person raising a complaint as well, or a grievance in relation to the redundancy process. So we need to make sure that the notifications to us are clear and detailed. Otherwise, we'll have to go back and ask more questions, or we wouldn't be able to accept it as a notification under the policy. And I think that's all for notification, but we will circle back to that later when we discuss some coverage issues later on.
So now I'm going to talk you through the policy definition of a claim. I'd just caveat to start with that we, as Julia was just saying, we'd encourage you to notify circumstances, threats of claims, but when it comes to considering coverage, one of the first things we'll look at is whether the policy definition of a claim has actually been met in order to trigger the policy. So I've got two definitions on screen. There are actually many more, but these are the two most common. And the important thing is that we need the demand for compensation and the allegations of a wrongful act. Often you'll get one and not the other, but it's important that both are there in order to trigger the policy. Also, another issue that we regularly have is that ACAS, when they first get in contact with an insured, will give them a call. So the insured will have no written evidence of what the claim is. And so something that's helpful for us is if the insured, as a first step, can ask ACAS to provide in writing what the employee is seeking and what they're alleging against the insured, and then you can send that to us, and we'll be in a much better position to consider coverage. And I'd also emphasise that this definition of claim, part A, can happen before ACAS are involved. So the insured might receive a letter or an email from an employee saying, I've been discriminated against and I want compensating for that. And obviously, depending on that, we can consider that for coverage under the policy as well. So it's worthwhile sending us anything you think might be a circumstance or a claim under the policy. And then just moving on to the next slide, for employment practice liability, the policy definition of claim gets slightly more specific, where it involves an employment wrongful act, which are things like unfair dismissal, discrimination, and also brings in that it's on behalf of any past, present, future, or prospective employee of the insured company, which is quite a wide definition of employee, and employees further defined in the policy. But I'd note that on Part B, that doesn't necessarily have to be an employee of the insured for harassment or discrimination claims. And trying to think if there's anything else I want to say on that, but
if I may just chip in quickly, with employment practices liability claims, as the definition states, a claim can be brought by someone who is not an employee. So we have to be really careful in terms of not just dismissing claims who are brought by prospective employees. So, for example, if someone goes for a job interview and they feel like they have been discriminated against by the insured, they can bring a claim, and there's a potential that that is a employment claim that will be covered by this policy. So from our point of view, and I think from your point of view, whilst we naturally talk about claims brought by employees against employers, please be aware that it can be past, present, or prospective employees who can bring claims, and there's a whole host of issues also with the self-employed, agency workers as well, which could potentially be caught, but we're not going to go into that level of detail today. But I think the issue is just don't make the natural assumption that it won't be caught, because it might well be.
And employment claim, the definition of employment claim still includes the definition of claim. So you still have to have that demand for compensation, even though it's not mentioned there. Next slide, please, Heidi. Thank you. Oh, you're on mute, Julia.
Okay, here we've got an exclusion that we often encounter when we're considering coverage for a claim. So when we have a claim, we often will just see one head of loss. It could just be discrimination or a claim for money owed, or we could see a claim that has lots of different heads of loss. And when we go through and consider coverage, one of the exclusions that often comes up is this employment benefits exclusion. This exclusion is intending to cover claims that would be intended for another policy like employment liability policies, but also the main reason we see it come up is because it relates to excluding cover for unpaid benefits, redundancy pay, holiday pay, notice pay, and other benefits that an insured may be entitled to under their contract. So this policy and this exclusion operates to exclude all financial loss connected to such claims for money allegedly owed, because it excludes all financial losses defined, which includes both defence costs as well as any settlements and awards. There is one right back, though, in relation to retaliatory treatment, and that would involve whistleblowing. So I'm just going to pass over to Anjali, who's going to speak a bit about whistleblowing.
Yeah, so we see whistleblowing claims a lot, because in the ordinary course of things, if you don't have 2 years service to bring an unfair dismissal claim, and we're seeing that more and more with the current state of the economy, who knows where we're going to end up. The way to get around that is to allege that you have basically suffered a detriment as a result of having blown the whistle. Now, that can be, for example, because of health and safety concerns, because you think that your employer has done something that's illegal or criminal. And the reason that, let's say, that you were dismissed was as a result of that whistleblowing. So whilst it might not be alluded to in such detail as, oh, I blew the whistle, then I suffered a detriment, what we have to do is make sure that if there is if the claimant is basically thinking that, or has not put it in such explicit terms, that that might be a whistleblowing detriment claim as well. So again, we have to look at whether that's covered under the policy, whether that falls within employee benefits, and actually what that means. And if a claimant is successful in terms of a whistleblowing claim, what they get awarded is the same as a discrimination claim. It's an injury to feelings award. It's not something in addition to. It's, well, okay, you've suffered that detriment, but what does that equate to? So it's, unfortunately, I'd like to say that there is some scientific, formula to it all, but the judge will just sit there and go, okay, finger in the air, how hurt do I think your feelings are? And again, when we look at those figures, as I said earlier, you're looking at about 12 to 15,000 in terms of any injury to feelings award. So it's not an insignificant sum when you sort of factor that into everything else. Back to you, Julia.
I think that's all from me on that slide, but just to be aware of it, and that the policy is not there or intended to cover claims which the insured or cover claims where a claimant is potentially entitled to money owed under their contract.
So now on to prior claims and circumstances. So the intention of this exclusion is to ensure that claims, circumstances and claims that are meant for each policy period are notified in that policy period and dealt with in that policy period. So if a claim is made before the current period of insurance incepts, then that claim needs to be notified to the prior insurance policy. So any claim, and this goes back to what Julia was saying about notification and also the definition of claim. If we ask for a load of information and amongst that information, there's an email from before the current policy period from an employee which meets the definition of claim, that claim won't be covered in the current policy period. Similarly, if any claims arise from the circumstances or claims which have been made in a prior period of insurance, they would also need to attach back to that prior period of insurance. And this is for whether you have continuous insurance with your current provider or if you're changing insurers. So I'd highly recommend you having detailed conversations with your clients at either placing time or renewal time to discuss whether there have been any ongoing disputes with employees, any threats of claims, anything which you might constitute a circumstance, and so that they are notified to the prior policy period. Another thing we often see kind of connected to this is non-disclosure. So it's really important to make your new underwriters aware or your renewing underwriters aware of anything which might lead to a claim in the next policy period. So if you're planning redundancies, for example, because when we think that there might be an instance of non-disclosure, we would go and talk to our underwriters, ask them if they're aware of any of the things that had come up. And if they weren't, then we'd ask them what differently they would have done had they known that knowledge when it came to underwriting that risk. And sometimes that can result in a change in terms and circumstances under the policy, or if it's really reckless non-disclosure, then it can mean that the policy is no longer valid. So really important to talk to your clients about what's been going on in the prior period of insurance and also what could potentially be coming up in the next. Next slide, please.
Okay, so I'm going to quickly run through some common coverage issues. I would say it's probably going to be quite quick because we're all desperate to hear from Anjali on the examples to bring them to life. So I'm going to just take these one at a time. So written consent, that's a policy condition within the Zurich wording, and this requires that our prior written consent is sought and obtained before any defence costs are incurred, legal representation is retained, the insured takes any steps with the defence of the claim, any offers are made or accepted, or any admissions are made, or any claim is settled. The reason for this we've probably touched on before is because if we're being asked to indemnify a loss, we cannot have a situation where an insured simply receives a claim, deals with it themselves, and then seeks contribution from us after the event. We need to be involved in the decision-making process and the strategy and decisions about settlement to ensure hopefully that the best possible outcome is achieved for the insured in relation to the actual settlement sum and also the defence costs being incurred. There is a risk if the insured doesn't seek our consent to costs that they will have to meet those costs themselves because the policy does only respond to defence costs incurred with prior written consent. So if we're not consulted, we'd need to look at how badly that has affected the position in relation to the defence of the claim, and we'd have to consider the consequences of that in relation to coverage. For example, we may have to say that we were unable to assist because the claim could have settled much earlier, potentially within an excess, and if that is the case, then we would not pay more under the policy than we know it could have been resolved for. So if the insured loses an opportunity to settle for a low sum, that can be very detrimental to them in respect of coverage. And we'd also potentially look at limiting our liability in other situations if they've dealt with the claim, but we can assess based on the information that's presented to us that we could have achieved a better outcome. Therefore, in that situation, we may contribute some, but not all towards the claim and defence costs. So that's something we offer encounter and have to engage with our insureds and brokers on. Moving on to conduct. With this, we're concerned about conduct both before a claim and after a claim, because the policy is there to respond to fortuitous losses. So when it's pre-claim, if an insured took advice, for example, from a solicitor and they were told not to take a certain step because that would result in an employment claim against them and the person would be successful in that claim, if the insured chose to disregard that legal advice and just take the action they wanted to, that would not result in a fortuitous loss because they took that action in the full knowledge that a claim would result and would be potentially a claim made against them, which they wouldn't be successful in defending. Moving on to conduct during the claim, this is involved with the insured making sure that they fully engage with us, and that's by provision of information, engaging with us in our panel about strategy to make sure that we, again, reach the best possible outcome. We have seen situations where insureds don't give us the information we need to be able to compile a good defence. In that situation, we have to consider the coverage consequences of that, because there should really be no reason why an insured would not engage with us in relation to the defence. And we'd want them to engage with us to make sure settlement was considered as early as possible to potentially lower any defence cost spend, because as Rose noted earlier, that can be sometimes significantly higher than the claim could be settled for. So in situations where this happens, we need to consider the consequences of this in relation to pre-claim situations. That could be, as I said, us saying that there's no cover because there would be no fortuitous loss. That could also happen during the conduct of the claim, where, for an example, an insured, by their conduct with the claimant, invites more claims upon themselves rather than just dealing with the one. If they continue to have bad engagement with the claimant and not leave it to our solicitors, then we have seen situations where second claims have been invited upon insureds, and in that situation, again, it wouldn't be a fortuitous loss. I'm just going to move on to dual insurance. When speaking about the notification condition, I highlighted that it's important that all relevant insurers are notified as soon as there's a concern a claim may be made or a claim has been made. That's very important for employment claims because there is often dual insurance, because legal expenses insurers often cover it. Unfortunately, we have seen situations where we haven't been notified straight away and the insured's gone to legal expenses insurers, and then we find months down the line legal expenses insurers decide not to continue with the defence because they don't consider it has a prospect of success over 50%. Then we're left with a difficult situation of deciding how to deal with the matter going forward, and we'd have to look at whether our position under the policy had been prejudiced, and also how the defence would be dealt with, given that it would involve other solicitors that we haven't had any engagement on and would have to spend a lot of time catching up on the claim, which could delay things from the insured's perspective, which we wouldn't want to do. We'd always want to consider coverage as matters go along. Late notification, I think we've touched upon that before by looking at the definition of claim and the notification conditions. But again, on this, I'll just highlight that although there is a difference between when to notify a claim or a circumstance, it would always be best to notify at the circumstance stage, because that way an insured would avoid any potential late notification issues. We could keep coverage under review and step in as soon as possible when a claim is made and the policy coverage is actually triggered. If there is uncertainty for the insured about when that claim is a claim as defined by a policy, we can avoid that uncertainty for them by actually reviewing everything and saying, this is the point the claim is made, and we'll respond from that point. So always best to do that. That avoids a lot of coverage issues we commonly see. Moving on to defensive claim. This again is a policy condition saying that the insured has to take reasonable defence in relation to the defence of the claim and shouldn't take any action that would prejudice our position. So this means that basically when a claim's made, we would expect them to notify, but if coverage is being considered, or if it's not at the claim stage and it's just a circumstance, they should take the steps required to defend the case to ensure that the coverage, the position in relation to the claim, is not prejudiced and we don't suffer a detriment as a result of any delays. We would always expect an insured to do that as standard, but sometimes there can be delays and insureds will not often take the steps required, and that can lead to a detriment. For example, what Angela mentioned, default judgments being made. So this condition is there to hopefully avoid that and make sure the insured takes all necessary steps in relation to the defence of the claim. I'm not going to talk about limiting liability because I think I've touched upon that in relation to the other issues I've discussed. So I think I'm just going to pass on to Angela to give us some examples now.
Thank you. Julie's actually stolen some of my best examples that I was going to talk to you about, because we've had a few recently.
Be more specific.
We've had a few recently with some insureds where we sort of, you know, Julie's touched on the issues about written consent and conduct during a claim. And I'd like to say the example that I'm about to give to you is an exception rather than the norm. But unfortunately, what we're seeing is insureds do tend to go off on a folly of their own, whether they think what they're doing is right or not. But we've recently had a claim for Zurich where one claim has been submitted, which was horrendous in itself, but the insured then took it upon themselves to send some very aggressive stroke harassing text messages to the claimant. And if I may paraphrase, basically saying, bring on a claim, you know, do your worst, we don't care what you're going to do. She did her worst. She then bought a second claim. The difficulty that we have then is that we cannot credibly deny the allegations against the insured. That has a massive impact on prejudice. One, there was late notification because they knew about the first claim to start with. They then didn't tell us about these text messages, and then all of a sudden couldn't find these text messages. Now, these were from directors of the insured who were like, no, unfortunately we've got new phones, so we don't have them, you know. And it did smack of Rebecca Vardy and Colleen Rooney in the courts going, oh yeah, my phone's now in the sea, you know. So it was horrendous. And actually, when you are given those examples text messages by the claimant by way of disclosure, and the insured is saying, no, this didn't happen. Unfortunately, the long and short of it is they're lying to you and they're lying to their insurers in terms of what they did or did not do. We had a real issue with that. And I think Julia may correct me if I'm wrong, but I think you declined to cover the second claim on that basis. But the first claim was still covered. But this was a real issue that we had going backwards and forwards with Zurich in terms of, well, they knew that they had done this. Why had they done this? And what effect does it have on both the conduct and the coverage of the claim? So these are real issues that we have. And also the ones I think Zurich probably see a little bit more than often in relation to this is the insured doing things, not getting written consent, prejudicing their position, but not only their position actually, but Zurich's position in terms of any communication that they might have with, for example, with ACAS. And you know, the whole purpose of the ACAS conciliation process is to try and stop that formal claim being submitted. But what tends to happen is if the matter is really emotive, the insured will take their bat and ball home and say, we don't want to get involved in this at all. But actually, Zurich gets it then at point of claim, sends it on to us as panel, and we look at it and go, oh, actually, we're dead in the water with this. But when we ask at early conciliation, what did the claimant want? And they say, well, they only wanted £2,000 or £3,000, or they wanted their notice period. Or I think in one case, they wanted a reference and they refused to give it to them. That significantly prejudices Zurich's position in terms of, well, we're now telling you that it's going to cost you, 20 to 30 grand, potentially, depending on what the claim is, to defend this, when actually you could have got away with it for £2,000 and probably within the insured's excess. So there are issues here with insureds either not understanding the implications of their EPL policy, not understanding actually what the EPL policy could cover as well, but actually their own conduct during any negotiations with ACAS, with solicitors. So, for example, Rose alluded to the fact that there might be some communication from individuals. So you could get something from ACAS, you could get a written grievance, you could get a letter before action from a solicitor's saying, if you don't settle this, we're going to issue a claim. All of that needs to be, at the forefront of the insured's mind and go, okay, what do I need to do? And actually, how is this going to impact on any claim that I might have to defend? So we often see claims where, one, it's late notification, they've instructed their own solicitors as well, and then gone off and spent a fortune in terms of doing the defence, haven't got Zurich's written consent to do that. And I think, I've been working with Zurich and Julia and Rose for the best part, I think 10, 11 years now, and we do see that more often than not in terms of insured not understanding that they need to get written consent to do this. Making admissions in claims, or making admissions when they're not realizing what they've said. So all of these things actually go to common coverage issues that we then have to flag to Zurich. So often when the new claim comes to us, and I'm afraid I'm a very long in the tooth respondent lawyer, you will know if the claim form has some merit to it. If it sounds too ridiculous to be true, it normally is true. So we can say from the outset actually whether there is some risk to a claim. If it's a process in terms of unfair dismissal, then we have to do a little bit more delving in terms of, okay, did they follow a fair process? Are we happy that that's all clear, and that the insured can defend the claim? Where it's discrimination claims, whistleblowing claims, it's a little bit more tricky because not necessarily supported by documentation, it might be supported by witness evidence. So all of these things then go to the insured's conduct during the claim. And unfortunately, we have had some situations where insureds haven't told us the truth. They tell us one thing as we're prepping for the hearing, we're at the final hearing, and they tell the judge and the two panel members in an employment tribunal a whole different story. I'm then on the phone to Julia or Rose or one of the other teams going, yeah, what was a fairly straightforward defence? Please, can I now have X amount of pounds because we need to try and settle this? So it's really important, I think, certainly from panel's view, that we have really good engagement with the insured. And they're not afraid to tell us if there has been a problem, if there's been a slight misstep in terms of a process, so that we can tackle that head on. But I think often what we face the most of is reluctance from the insured to settle matters. Even if they're being told that actually you're dead in the water, the documentation that you have just doesn't support your position. I think we've got one at the moment. I think Rose and I have got one at the moment where we're saying, we're not going to win this. And we're like, no, it's the principle of the matter. I don't want to pay this person any money. The principle of the matter is only going to get an insured so far before Zurich starts saying, but they're going to go away for £10,000, and we're being told by panel that it's going to cost us £35,000 to defend this. So there is a real conflict there as to how to manage that relationship, both with our insured client and our insurer client, because we wear two hats, but our overriding relationship is to Zurich as our insurer client. So those are just a few of the examples that we have. I know that there are some questions in the chat function, so I don't know if Rose or Julia have anything else they want to add before we go back to Heidi.
Just one quick thing is it's best that we ask that the insured does not let the claimant or claimant solicitors know that insurers are involved, because that may also prejudice their and our position. That's just a small point.
Perfect. Well, thank you, Rose, Julia, and Anjali, for a really interesting session. I can see we've got lots of questions that have come through already. So I will start going through these. First question, do Zurich accept EPL claims before ACAS are involved? Many insurers don't accept before they've been in touch.
I think that's a quick answer, yes, on that one, and it depends whether we accept and deal with the claim on whether it meets that definition of claim and employment claim. If it does, regardless of whether it's an ACAS claim stage, the policy would start to respond if we've got that demand for compensation, allegations made, and wrongful acts identified. So yes, it would potentially.
Lovely, thank you, Julia. Question from Ian. Would it be fair to say if claim settled at ACAS early conciliation, then claim would be below 2,500 or the excess?
Not necessarily.
I think
It all depends.
Yeah, it very much depends on the claim. You know, if we can get it below £2.5 grand, I think all of us are jumping for joy. But if it looks like it's going to be a little bit more than 2,500, and we're dealing with it from panel's perspective, what we will do is report to Zurich and say, actually, do you know what? To get us to the next point, it's going to cost X amount of pounds. But actually, if we can resolve it now, then it's worthwhile doing. So some do fall within the excess, but I think the reality is not all do.
I mean, can I just jump in on that point from an underwriting perspective? As Tony Statham, head of financial lines for the regions here in the UK, £2.5 grand is extremely low. Excuse me, as a deductible, and I don't think we will see that really from anybody else in the market. And to be honest, for those on the call, it's something that we are continuing to look at. I don't think I've ever seen, from however many years of doing financial lines, an EPL claim less than 2.5 grand.
Yeah,
it just doesn't happen.
Yeah, Tony, I also would say we work with a number of insurers, and Zurich's is the lowest.
Yeah,
that I've seen.
So I keep getting told by my boss. But
yeah, yeah, most of them now are 5 figures.
I'll pick up on this next one, sorry, if that's all right, Heidi, from Barry.
Yeah.
Getting guidance now on our ERS form, which is our management liability, D&O, corporate legal, EPL. We have DAS, who you have a free consultation service with. There's a number on the policy, so you can always ring them for sort of free, non-prejudicing advice, if you like, as to whether it's our claim should be notified. But look, I think the notification point was covered during the presentation, that if you're in any doubt, notify.
Mm-hmm.
That's regardless of the policy. If you're not sure, let us know.
Definitely.
You will never be penalised for notification in terms of renewal terms or whatever. It may get to a point, and we have had this conversation with our claims colleagues about what should and should not be notified, because no one's going to, there is always a fine line. But if you're not sure, notify. Speak to DAS. If you're still not sure, let us know.
Can I just jump in there and say that please be aware, though, that contacting DAS would not constitute a notification to us. So don't fall foul of that by thinking you've spoken to DAS and that's it notified to Zurich. That wouldn't be the case. But speak to everyone would be my advice.
Yeah, and if you're not sure, you can always speak to us anyway, and we can advise you further.
Lovely, thanks everyone. Question from Sarah. How do you approach notifications when the insured has 2 policies triggered by their EPL claim, i.e. EPL and legal expenses? How would you recommend the insured handles these at the outset? For example, we often find that both policies want their own panel solicitors instructed, which may delay matters when there are deadlines to be met.
I'll take this one, if that's all right. We in financial lines in Zurich don't write legal expenses. We write EPL. Now, I think we have legal expenses extensions on some of our commercial combined wordings. Some people on the call probably know better than I do. It will always lean towards the more appropriate insurance clause that is in basically everything. Now, EPL is much wider than legal expenses. I think it was mentioned during the presentation that there has to be a 50% chance of success, and you have to go through all these different hoops for legal expenses to kick in. Now we don't have we have panel solicitors. One's on the call now. But if an insured has somebody they would much prefer to use for these matters, has used them before, we get fee agreements, we know them from a claims perspective, then from an EPL, and please jump in if I'm getting this wrong, claimsers, but they can use whoever they want, as long as they are competent, reasonable charge, know what they're doing. So, you know, if there is both legal expenses and EPL, and they're both with Zurich, notify both and we'll sort it out between us.
Yeah, and I'd just go one step further on that as well, that if where there is potentially two policies responding, then it would be for the two insurers, I guess, to fight out between themselves of what if two of them are going to contribute, or whether one will contribute until the limit's exhausted, etc.
Thank you. Got a question from Tom who said, not sure if I'm allowed to ask questions. Of course you are. How common is it in the current climate of increased accountability for the directors or officers of businesses to be named alongside the entity in an employment tribunal?
It happens more often than not. So if you have a named respondent in addition to your insured entity. So your insured entity, if it's a bog standard employment tribunal claim, so for example, unfair dismissal, you can't bring an unfair dismissal claim against an individual. Your unfair dismissal claim is brought against your employing entity, typically you're insured. In addition to that, though, you can have named respondents where allegations of discrimination or whistleblowing are made against people. It's very common, you know, there's very few that probably don't have named respondents on at the moment, but what we try and do from the outset is, one, determine whether there's any potential conflict, because if there are allegations of discrimination, we have to make sure that actually if there is a conflict, we are highlighting that early with Zurich and your insurers, because if the individual has gone off on a folly of their own and basically have been doing things that they shouldn't have been doing, then you have to consider whether there is separate representation for them. Typically, they will be covered under the policy once we've worked through all the definitions, claims, whether they're covered. But then the issue that you then have is potentially two sets of defence costs. So one for the insured entity, one for the individual who's getting separate representation from somewhere else. But long and short of it is, yes, they do, and they can be named in employment tribunal proceedings.
Thanks, Anjali. Next question, do you cover TUPE claims?
I can take the next two actually in quite quick succession, but I'm also conscious that we are towards the end of the session. So what I'm going to do is put my contact details in the chat. So if anybody has any questions on underwriting or whatever, please let me know. So I'll just send that over. But just to preempt a question, no, we don't write this in isolation. So we would have to have the D&O and everything else to consider EPL from a financial line perspective. So going back to the TUPE question, so I'm just going to share my screen. I've got the policy here. Hang on, I should be able to do this by now, shouldn't I? So there you go. Do we cover TUPE claims? Yes, we do. And there it is in the wording. Now, the question below that was to do with, would we cover agency? And again, yes, we do. So I'm going to go to the definitions sections. Employee is here. So employed by insurance company on a labour only basis, hired or borrowed from another employer, voluntary help works with him. So yeah, you know, agency workers certainly aren't excluded. So hopefully that was quite a quick fire. Double answer.
Yeah, I would say, Tony, actually, from Zurich's perspective, we have had a few situations where we've managed to push back in terms of agencies, because it depends how they are serviced by that agency, and I won't go into too much detail, but we then start to talk about umbrella contracts and IR35. So initially, yes, but then I think there requires a little bit more delving into those types of issues.
I think that's a very complicated issue actually, and does take a lot of detailed investigation on that one.
Okay, thanks all. Next question, regarding the employment benefits exclusion, wouldn't these type of things often be what the disgruntled employee is asking for? Would you pay the policyholder's defence costs in this connection?
If it's purely a claim for money owed, then we wouldn't pay the defence costs or the settlement, just because I think I said earlier, the exclusion excludes all financial loss, which is both excluding defence costs and settlements and awards. It could be that the employee is asking for something else as well in relation to unfair dismissal or discrimination. Obviously, in that situation, we would have to consider allocation and pay the fair part that we consider would fall under the policy, but there would potentially be an element that would be uncovered for those money claims.
Yeah, it's a valid question, isn't it? And I think the crux of it is, look, if an employers have duties to their employees, and so if they just decide to sack a load of people or whatever and not pay them, they can't. You know, we're not just going to pick up the tab for that.
Yeah, I think that goes back to it not being a fortuitous loss again, really,
Yeah,
as well, doesn't it?
yeah.
And that's why the policy's not there to cover that.
So they have to treat their employees, you know, according to their employment contracts. This policy is for anything that sort of falls foul or is you know, there's sort of egregious matters wider than that. But it's not just to pick up the tab when, because otherwise they'd just notify everything and we'd have to pay it.
Sometimes though, an employee will be demanding compensation, but they'll base it upon their wages. So that's a situation that would be considered for cover, because they are asking for compensation, but they're saying, I want 3 months. They're not owed 3 months. They just think that that's what their claim's worth. Just to be aware of that.
Next question, is the policy on a claims made basis? And if so, is there run-off cover for it if it goes past the 45 days?
It is a claims made policy, so it responds to claims made and notified during the policy period. That 45-day allowance is to allow for when the claim has been made against the insured in the policy period, but for example, it takes them a little while to gather the information they need to actually send on the notification to insurers. So it's not kind of extending cover in any way. It would still be a claims made policy and only responding to claims made during the relevant period.
Yeah, and look, from my perspective, runoff doesn't really seem to be an issue in EPL. There isn't the tail to EPL claims as there is in D&O or crime or covers like that, or professional indemnity, that, you know, people know quite quickly whether they're feeling disgruntled, discriminated against, you know, they've been wrongfully dismissed, whatever it is. So that it tends not to surface after months, years, as it can do in D&O.
Thank you. On the dual insurance point, again, appreciate what you say regarding dual insurance. However, where both insurers want to take control of the claim for the same reasons, would you recommend that both insurers discuss directly to agree on one approach at the outset to avoid any potential delays?
I think that's one for
Yeah,
claims.
I think that's sensible idea. Often we try and involve our brokers to get that engagement, because they're the ones that are able to put the pressure on the other insurers to get a response to them, so they don't use delaying tactics to just hope the claim under their policy will go away and go to another insurer. But we're always happy to speak direct to other insurers to move it along and make sure that we have those discussions and make decisions about the conduct of the claim early on.
Perfect, thanks, Julia. Do you waive the excess if complied with ACAS code of conduct and use panel solicitors?
No, is the short
No.
answer. We used to, way back when, have a first excess free clause in the policy. We don't anymore, because look, this is just so prevalent now. You know, if I think Tom, who's one of our financial lines underwriters, made the point around increased accountability of directors, and look, you know, the Me Too movement, you know, there's just so much now that is claimable, and, you know, quite rightly, that it's just not viable to have a first excess free. If we have the lowest deductible in the market for the moment, we can't then have a free excess, because look, they should be compliant with ACAS codes of conduct anyway. And whilst we do have panel solicitors, and again, please jump in if I'm incorrect on this, but who we use a lot of the time, we don't force anybody down that route as long as they are using, again, somebody competent, somebody with a fee agreement, somebody who we are comfortable with the insured using. So no, there's no provision for excess waivers.
Thanks, Tony. Is there a central register of claimants to detect or prevent potential fraudulent claims, e.g. one person makes claims against a number of employers who have not employed the claimant?
I can probably take this one and the next one. So no, there isn't. Unfortunately, if there was, it would make everybody's life a lot easier. So there is the central register, so employment tribunal database you can access. So you can do a search of the individual's name. The issue is that they probably won't give you any details. For example, if there's been a settlement, it will just say claim dismissed. If it went to final hearing, there might be a copy of the judgment. It takes a lot to get to a point where the tribunal or any courts will issue a vexatious order against a claimant. We've got a couple at the moment where we do have that, but I'm afraid long and short of it is no, it's not. It's really unfair if it's a vexatious litigant, and I absolutely get that. But there is unfortunately nothing that we can do about that particular point. And I think the next question was, would DAC be able to deal with a claim in Jersey de-restriction? We don't have an office there per se, but we do have an associate firm that we do refer work to.
Perfect. Thanks, Anjali. I think, so having look through the rest of the comments, I don't think there were any other questions in there. So conscious of time, we'll bring this session to a close, but thank you so much to everybody for joining today. And then also thanks, of course, to Rose, Julia, Anjali and Tony for presenting and answering all your questions. Brilliant engagement today, so thank you. And I will hopefully see you all soon on another webinar in the next few weeks. Thank you.
Thank
Thank you.
Thanks.
Thank you.